Sa problem na to, about siya sa liability. So, M Incorporation and G Incorporation entered into a joint venture agreement. Ano ba yung joint venture? It is a legal organization that takes the form of a short-term partnership in which the persons jointly undertake a transaction for mutual profit or agree to pool their resources for the purpose of accomplishing a specific task. Generally, each person contributes assets and share risk. Balik tayo sa problem. M Inc. and G Inc. entered into a JVA for the construction and development of an office building on a land owned by M Incorporation in Makati City. The joint venture engaged the services of X Incorporation to provide subsurface soil exploration, laboratory testing, seismic study, and geotechnical engineering for the project. X Incorporation then billed the joint venture for 284,553, representing the cost of partial subsurface soil exploration, and for 250,800, representing the cost of the completed seismic study. Despite repeated demands from X Incorporation, the joint venture failed to pay its obligations. Meanwhile, due to unfavorable economic conditions at the time, the joint venture was cut short and the planned building project was eventually abandoned. X Incorporation subsequently filed a complaint for collection of sum of money against M Incorporation and G Incorporation. Ayan na yung tanong. Which between joint ventures M Incorporation and G Incorporation bears the liability to pay X Incorporation its unpaid claims? Sagot ay M Incorporation and G Incorporation. Parehas sila are jointly liable to X Incorporation. Kasi sabi dito, a joint venture being a form of partnership is to be governed by the laws on partnership. Article 1797 of the Civil Code provides. Ito na yung Article 1797 of the Civil Code provides. The losses and profits shall be distributed in conformity with the agreement. If only the share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. In the absence of stipulation, the share of each in the profits and losses shall be in proportion to what he may have contributed, but the industrial partner should not be liable for the losses. As for the profits, the industrial partner shall receive such share as may be just and equitable under the circumstances. If besides his services he has contributed capital, he shall also receive a share in the profits in proportion to his capital. Sa problem na binigay in the joint venture agreement na M Incorporation and G Incorporation agreed on a 50-50 ratio on the proceeds of the project. They did not provide for the splitting of losses. Sinabi nga sa Article 1797, if only the share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. So, 50-50 rin yung magiging share nila sa losses. The same ratio applies in splitting the 535,353 obligation loss of the joint venture. Proceed sa next topic, which is third person designating the share of partners in the profits and Losses. Article 1798. If the partners have agreed to entrust to a third person the designation of the share of each one in the profits and losses, such designation may be impugned only when it is manifestly inequitable. In no case may a partner who has begun to execute the decision of the third person, or who has not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of such decision. The designation of losses and profits cannot be entrusted to one of the partners. Dito natin ngayon malalaman kung valid ba or void ang stipulation ng mga partners. Isa-isahin natin. So, if the share in profits and losses is to be determined by one of the partners, hindi pwede. For example, A, B, and C ay nagtayo ng partnership. And then, napagdesisyonan nila na si B na lang ang magdidetermine for the distribution. Hindi po yun pwede dahil mawawala yung fairness. What if naman kung sina A, B, and C ay nagkasundo na ang magdetermine for their distribution ay si N? Sino si N? Siya yung third person. Pwede ba yun? Yes, pwede. Tingnan nyo na lang yung difference sa kanilang dalawa na if one of the partners ang magde-decide for the distribution, bawal. Pero kapag third person ang magde-decide for them, pwede. Pwede, pero hindi final yung decision na yon dahil pwede po siyang ma-question on the ground of inequitability. For example, sinabi ni N 40% kay A, 50% kay B, tapos 10% kay C. Yun yung, kumari, yun yung distribution of profits. Si C pala ang may pinakamalaking contribution. Tapos siya pa yung may pinakamaliit na makukuha. Pwede niya ngayon questionin yung decision ni N. Kaso 'di ba, napagdesisyonan ng partnership na ang mag-decide for the distribution ay si N. Oo nga, si N nga ang magde-decide for the distribution nilang tatlo. But pwede nilang questionin yun due to inequitability. Pero, hindi yon absolute. May exemption din yan. Hindi absolute na pwede niyang questionin on the ground of inequitability yung decision ni third person. Ayan, lipat na tayo sa kabilang slide. Yan, dito tayo sa may exemption. Meaning, hindi absolute na pwedeng questionin ni C on the ground of inequitability yung decision ni third person. Kailan niya hindi na pwedeng questionin yon? Ayan, first, kapag na-implement na or execute yung sharing na dinetermine ni N o ni third person. Another exemption. Yan, pangalawa, kapag tinanggap or kapag tumanggap na, for example, si C, tinanggap yung 10% share and hindi niya question yung natanggap niya within 3 months. At isa pa, nalaman niya na yung decision ni N na 10% share yung kanya pero hindi siya umimik. Pinabayaan niya lang sa loob ng 3 buwan, 3 months. Wala na. Wala na yung rights niya to question the decision of the third person. Ayan, tandaan nyo yung 3 months rule. In short, kapag, ayan, sa kabuuang Article 1798, kapag, ano ba yan? Kapag among the partners ang magdidesisyon for the distribution, Hindi pwede kasi nga mawawala yung fairness. Pero kapag nagkasundo ang partners na third person ang magdetermine for the distribution, pwede. Yung decision ba ni third person ay final? Hindi. Pwedeng questionin on the ground of inequitability. Except na lang, meaning hindi mo na pwedeng questionin kapag tumanggap ka na and hindi kumibo within 3 months. Yan. So, next. Yan. Article 1799. A stipulation which excludes one or more partners from any share in the profits or losses is void. General rule. Take note that what is void is the stipulation only and not the contract of partnership. Hence, the profits and losses shall be distributed as if there was no agreement as discussed in the preceding article. Exception. An industrial partner is not liable for losses unless he waived this right. Itong Article 1799, tinatawag siya na Pactum Leonina. Basta Pactum, void. Yan, yan. Sample, may stipulation kayo na hindi makaka-receive ng profits or losses yung isang partner. Yung stipulation na yun, yung void. Pero ang sabi nga dyan, but the partnership agreement or partnership contract is valid from the nature of partnership itself. Partners contribute to a common fund, money, property, industry, yan, with a purpose of doing a business and earning from that business. The earnings of profits from that business is going to be distributed among the partners. Tapos, stipulation to exclude one or more partners from any share in the profits or losses. Sino yung niloko mo? 'Di ba? Kaya void yung stipulation na yan. Now, if sinabi na ang stipulation excluding the industrial partner, valid ba yon? Yes, valid. Kasi nga, si industrial ay hindi pwedeng magkaroon ng share sa losses. Wait, andito na yan. Yan na yung why an industrial partner is not liable for losses. Bakit nga ba hindi liable si industrial partner sa losses? Kasi batas na po ang nagsabi niyan. Magkakaroon lang ng losses si industrial if hindi siya pure, meaning capitalist industrial partner na kanina ko pa nga sinasabi sa example. Isa pang reason is while capitalist partners can withdraw their capital, the industrial cannot withdraw any labor or industry he had already exerted. Moreover, in a certain sense, he already has shared in the losses in that. If the partnership shows no profit, this means that he has labored in vain. Totoo naman kapag walang kinita yung partnership, unang-unang magkakaroon ng loss dyan or pinakamaapektuhan dyan is si industrial partner kasi nga effort and yung pagod yung inambag niya sa partnership tapos hahanapan mo pa ng loss ay ng share niya sa loss. Yun na nga yun ano yung dodoblehin niyo pa. O di ba? O proceed tayo sa article 1800. Yan. The partner has been appointed manager in the articles of partnership may execute all acts of administration despite the opposition of his partners unless he should act in bad faith and his power is irrevocable without just or lawful cause. The vote of the partners representing the controlling interest shall be necessary for such revocation of power. A power granted after the partnership has been constituted may be revoked at any time. Yan. It is the rights and obligations with respect to management. Basically, Article 1800 pertains to two types or dalawang types on how appointing a managing partners. First one is, andyan, managing partner is appointed articles through the articles of partnership. Ibig sabihin, dun mismo sa kontrata. Mismong sa article ng partnership. Sample, partner N will be the managing partner of the partnership. Yan. Second type naman ng appointing a partner as a manager to the partnership is after the constitution of partnership. Meaning, na-designate lang, for example, si partner N as managing partner after ma-execute yung articles of partnership, after na-execute yung contract. Tanong, posible ba matanggal ang managing partner? Yes. And based sa two types na yan na sinabi ko or dyan sa article na 1800, they can be removed in different ways. Why? Because sa unang type na nabanggit, na through the articles of partnership, the power of managing partner is irrevocable without just or lawful cause. Meaning, pwede niyang gawin ang kahit na ano sa pag-administrate niya or pag-manage niya ng partnership as long as it is not unlawful, hindi labag sa batas. Walang magagawa yung ibang partner because of the power he has as managing partner is based on the articles of partnership. Nanggaling mismo sa kontrata nila yon. That is why wala silang pwedeng gawin. Mare-revoke lang yung power as managing partner kapag may ginawa siyang invalid faith. That is unjust and unlawful. Kasi yan yung reason na nakalagay sa kontrata na napagkasunduan ng partners. Ngayon, paano nila matatanggal as managing partner kung gumawa siya ng action in bad faith? Yan, paano nila matatanggal as managing partner kung gumawa ito ng action in bad faith? Through votation. Yan. Both of the partners representing controlling interest necessary to revoke power. Meaning, percentage, let's say si A, B, and C, ang total of controlling interest nila is 40%, while si D and E naman ay 60%. Since sila yung may mataas na percentage sa controlling interest, kahit dalawa lang sila pa rin yung masusunod sa paggawa ng desisyon sa kung ano ang gusto nilang mangyari. Kung ano yung vote ni na D and E, yun ang masusunod kasi yung basis ng pag-vote is based on the controlling interest. Now, paano kung si managing partner ay may controlling interest? Ayan, patay na. Let's say, meron siyang 70% interest. Walang magagawa yung ibang partners. Kasi kahit na unlawful, unjust, or in bad faith man niya ginawa yung action niya, hindi nila mare-revoke yung power ni managing partner kasi si managing partner yung may 70% na controlling interest nga. Scenario lang yan for additional information. Ganon kalakas ang power ni managing partner to appoint if through articles of partnership. As managing partner kasi, ang pwede niyang gawin is yung mga necessary and incidental powers to carry out the object of the partnership in the transaction of its business. Ito yung primary function niya. Next step naman is which is a partner being appointed as manager after the constitution of the partnership. Gaya ng sinabi ko kanina, after na-execute yung partnership, after nagkaroon ng legal existence, tsaka lang pinag-usapan ng mga partners kung sino ang magiging managing partner. Regarding sa power as managing partner sa type nito, anytime pwede siyang ma-revoke for any reason. Kahit na in good faith man niya ginawa, kahit na wala siyang nagawang kasalanan. Okay? Kahit yung di mo lang feel na siya yung managing partner, pwede siyang ma-revoke as managing partner. Paano? Same with the controlling interest na nabanggit ko sa unang type. That's all my report. Thank you.